An apparently experienced defense attorney screws up cross-examination big time. Come join me for a moment as I share with you exactly what happened. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now I took my daughter, who's a college freshman, to court. And now she wanted to see what it was like being in court. She wanted to see what a trial was really like. She wanted to hear witnesses. She wanted to hear attorneys yell objection. She wanted to see what the judge would do in light of an objection that's made. And importantly, she wanted to see what the jurors did while testimony is going on. So I took her into court in Mineola in Nassau County here in New York. And now we went from courtroom to courtroom to see if there were any ongoing trials. A little further down the hallway, in a courtroom that we walked into, was a dog bite case going on. We sat down, and now here's the scenario. On the witness stand is the injured victim. She is being cross-examined by the defense lawyer. The defense lawyer appears to be someone who is very experienced. He's got gray hair, he's wearing a gray suit, a white shirt, a tie that's unremarkable, and I don't even remember what color it was. And now, here's something fascinating. He's asking this witness cross-examination questions, and every question that he's asking her starts with her name. Let's say her name is Mrs. Jones. Mrs. Jones, isn't it true you did this, this, and this? And now, in an accusatory tone, every single question he's prefacing by using her name, as if that adds to the antagonism. Mrs. Jones, didn't you do this? Mrs. Jones, when you first went to the hospital, isn't it true you made the following complaint? Now, at first it sounded interesting, but after the 5th, 6th, 7th question, it really got to be very annoying. What that told me, what that signaled to me, was that this attorney didn't know how to mix up his questions. That told me that this attorney didn't know how to vary his questions. You don't want to ask the same type of question the same way over and over and over again. It gets boring really, really quickly. So now, this wasn't the best part. The best part is when this attorney tried to ask this witness a series of questions that contradicted something she said about a year earlier when she gave pretrial testimony. Now, you should know, in any accident case, in any medical malpractice case or wrongful death case, when you go through the litigation process, the person who is bringing the lawsuit is known as the plaintiff. And during the course of the litigation, there will be an opportunity for the defense lawyer, the attorney who represents the people whom you have sued, to question you in a question and answer session that's given in your attorney's office, in his conference room. Now, you should know that there's no judge present, there is no jury present, but what you do need to know is that there is a court reporter present. And the court reporter is there to record all of the questions that you are being asked, as well as all of the answers that you give. And the information that's recorded by this court reporter then gets transcribed and put into a booklet known as a transcript. And it looks something like this. You should also know that the answers that a witness gives during this deposition, which is what it's legally called, carries the same exact weight as if the witness is testifying at trial. So now when the case comes up for trial, let's say a year later, how do you actually use this pretrial testimony at trial? Well, the answer is one of the best ways to use it is to use it to contradict the witness, to show to the jury that what the witness has said a year earlier when she was asked questions in the comfort of her attorney's office was markedly different than the testimony that she's giving now at trial. That's how you use it. That's a very powerful tool. Except there was one problem here in this case. The attorney who was trying to cross-examine this injured victim didn't have any clue, didn't have any idea how to use this transcript on how to really cross-examine this witness. So let me show you how this is done. Let's say this is a medical malpractice case, and I am now questioning the gynecologist. You, the patient, have made a complaint to the gynecologist, okay? Dr. Jones, isn't it true that when my client first came into your office, she had a complaint of a breast lump in her left breast? Yes. And isn't it true that in addition to the breast lump, she also complained of having pain in the breast lump area? Yes. Isn't it also true that the patient complained of having headaches? No, it's not. Isn't it true, doctor, that the patient also had complaints of vaginal bleeding for 2 weeks? No, it's not. Isn't it true that the patient had the following other complaints? No, it's not. Are you absolutely certain, doctor, looking at your medical records, looking at your notes, that the patient did not complain of anything else except a breast lump and breast pain? And he looks at his notes and says, yes, that's correct. Now, why have I done that? What I've done is I've locked the doctor into his testimony now at trial. I want the jury to understand that this is what the doctor is telling them. Remember, the jury doesn't know what went on during the pretrial question and answer session yet. They don't know what questions he was asked a year earlier. They don't know what answers he gave. They were not present during that process. So now this is the very first time they're hearing information from the doctor. And now I want them to understand that the doctor claims that the only complaints that my client has made is that she had a breast lump as well as pain in and around the breast lump area. In this particular example, I'm just using this to show you the clear contradictions. And that's the difference. You don't want to use this over and over again during the course of cross-examination. You only want to use it where their contradictions are so clear, where the witness says one thing at trial and now says something totally different during pretrial testimony. So now I turn around and say, Doctor, you've now told us that the patient only had a complaint of a breast lump as well as pain in and around the breast lump area. Do you remember a year ago I had an opportunity to question you in your attorney's office? Yes, I do. And during that time there was a court reporter there, correct? Yes. And she recorded all of my questions and all of your answers, correct? Yes. And then she transcribed that information into a booklet, correct? Yes, it looks like this. And you received a copy of that booklet known as a transcript. Isn't that true? Yes. And you were told to read that transcript, right? Yes. And you were told that if there were any corrections or changes, to make them in the booklet and also on a separate piece of paper. Isn't that true? Yes. And you were to sign that booklet as well as sign any corrections that you made. Isn't that true? Yes. And doctor, you did read the booklet, correct? Yes. And you didn't make any changes. Isn't that true? Yes. Terrific, doctor. Now, let me read to you from page 21, line 9, the following question and the following answer. Doctor, when my client came to you on January 1st, isn't it true that she complained of a breast lump? She complained of pain in the area of the breast lump. She complained of having headaches. She complained of vaginal bleeding for 2 weeks, and she had other complaints. Answer, yes, she did. Doctor, were you asked that question and did you give that answer 1 year ago during your pretrial testimony? Yes or no? The doctor has to say yes. So now that's a significant contradiction to what he just said at trial. That's important. And now I can use that contradiction to show to the jury that this doctor is being less than credible. That's the key. That's why you use a transcript from prior testimony to now show to the jury that the information the doctor has testified now at trial is markedly different than what he said a year ago during his pretrial question and answer session. So now let me share with you what happened as my daughter and I are watching this horrible cross-examination. The attorney is fumbling. He can't find the right page exactly where he wants to be to find out and to use the prior testimony to cross-examine the witness. So after about a minute of fumbling around, he finally gets to where he thinks he needs to be. And then he starts reading. He's reading an entire page. And I'm wondering, where's the question? Where's the contradiction? Where's the confrontation? Nothing. He gets to the second page, and as he's reading through the second page, the judge stops him and says, Counselor, where's the contradiction? He's like, Judge, I'm showing the contradiction. He's like, no, you're not. There's no contradiction here, Counselor. I'm reading along, and there's no contradiction. You can't use this unless you're going ahead and showing the contradiction. Now, I will tell you that you can actually read portions of pretrial testimony to the jury, but you don't want to do it with the witness still sitting up on the witness stand. Once the witness leaves and you're done questioning that witness, when you call your next witness, instead of calling the next witness, you can turn to the jury and say, ladies and gentlemen, I'm going to be reading to you portions of testimony that Mrs. Jones gave when I questioned her a year ago. And now I can read different portions, different segments of that testimony. That's fine. But if you're going to use it to cross-examine a witness, and now you're confronting the witness with that testimony, you don't go ahead and read 2 full pages of sworn testimony that don't contradict anything. So now the judge is going like this. He's like, he can't believe what this lawyer is doing. It's obvious to everybody in the courtroom that this guy doesn't know what he's doing. He's not using this tool appropriately. And he tells them in front of the entire jury, hey, listen, that's not how you use this transcript to go ahead and cross-examine this witness. You just don't do it. And now he tries to find the next part where he thinks there's a contradiction. So he goes on, he reads another half a page. And you know what? There's absolutely no contradiction. The judge is shaking his head. The jury is getting their cues from the judge, and they're also shaking their head. And it's clear to everybody in the courtroom what just happened. What just happened is that this defense lawyer was schooled, this apparently experienced defense lawyer was schooled by the judge that this is not an appropriate way to use a transcript to cross-examine a witness. Only where you have clear distinctions between pretrial testimony and the testimony that she gave at trial, only then do you really want to use that. And remember, I said you use it sparingly. Because if you keep trying to use it over and over and over again in different ways where there's no real great contradiction, the jury's going to look around and say, why are you doing that? What are you doing? Why are you reading this testimony? It's got nothing to do with anything she said up on the witness stand. That destroys the attorney's credibility. And you should know, not only is the witness's credibility key, but the attorney has to maintain their credibility throughout the entire trial. And if the attorney loses their credibility, how then can the jury accept anything that the attorney is saying after that? That becomes a challenge. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what went on in a trial that my daughter and I went into to sit down and observe. And I often tell people, and I told my daughter this, I said, listen, you can learn so much by going and watching an attorney do things right. And you can learn so much more by observing what attorneys do wrong. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.